Welcome back to a truly explosive courtroom breakdown. Today, we're diving deep into a case that is layered with dramatic complexities, murder charges, serious jailhouse incidents, and profound questions about mental health. At the center of it all is a young man whose behavior in custody may very well determine his entire future. Meet John Jones, a 17-year-old facing a murder charge and held on a staggering $800,000 bond. This hearing is about to get intense. Jones isn't a typical defendant. He's been in custody for several months, all while the person who reportedly pulled the trigger has already been sentenced to 30 years. But the real story lies in what has happened since he's been locked up. A mountain of misconduct in just the last 2 months. Jones has amassed pages upon pages of jail incident reports. We're talking about more than just minor infractions. These are serious allegations, including multiple fights, direct threats against officers, and a consistent pattern of disrespectful behavior. The list of his alleged misconduct is extensive and alarming, making his situation far more complicated than his initial charge. His defense attorney is fighting tirelessly to get that massive bond reduced, arguing for his release. However, the prosecution is prepared to use this lengthy record of misconduct as powerful evidence against him. What makes this case even more compelling is the mental health angle. Jones's legal team claims he has been experiencing auditory and visual hallucinations and hasn't been receiving his necessary medications. This presents a critical question. Is this a legitimate medical crisis or a calculated attempt to manipulate the legal system and garner sympathy? And just wait until you hear the judge's reaction to all of this. She is known for her directness and has shown zero hesitation in holding defendants accountable. This hearing is set to expose the harsh reality of what happens when individuals believe the rules don't apply to them, even behind bars. Get ready, because this courtroom drama is about to reach a fever pitch.
You are John Jones? Yes. And Mr. Jones is charged in cause number 25 DCCR 0523 with the offense of murder. And Mr. May. And in cause number 24 DCCR 2431 with the offense of unauthorized use of a vehicle. Mr. Wilkerson has filed a motion just in the murder case, correct? That I reduce the bond.
Yes, Your Honor. Which I believe is set at 800. If I remember.
Let me pull it up so we make sure. Let's see.
Let's quote because I have had several of these.
It looks like in the motion it shows the murder is set at $800,000. And Mr. Wilkerson, do you intend to call your client or other witness?
Your Honor, I just intend to call my client and then also Venetia Jones if she is still present.
Mr. Johns, best you can, raise your right hand. Or Jones, I'm sorry. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can go ahead, Mr. Wilkerson.
Ms. Jones, you are obviously the same John Jones charged in this case with murder. You also have a companion case in which you are charged in a separate offense with unauthorized use of a motor vehicle. Is that correct?
Yes, sir.
And how long have you been incarcerated?
About 3-4 months.
And during that time, has that time you had the murder charges pending during the entirety of that time? Is that correct?
Yes, sir.
Now, the person who actually pulled the trigger with regard to this offense has pled guilty and been sentenced. Is that correct?
Yes, sir.
And that was to 30 years. Is that correct?
Yes, sir.
And he was on parole at that time, correct?
Yes, sir.
And until previously, at least as of the 24th of July, you have been off of 35, correct?
Yes, sir.
All right. Now, during the time that you have been incarcerated, you have had some run-ins with staff with regard to some behavioral issues. And obviously, if the court is going to consider lowering your bond and how you would be able to behave or would behave in the community at large, were she to grant a reduction in your bond, there are some concerns. And so I would like to give you the opportunity, encourage you to emphasize conditions that the court might be able to impose that you would be ready and willing to follow that might curb some of those concerns for the court while the case remains pending.
Yes, sir.
Go ahead.
Let me say, while the write-up thing was going on and going around, I didn't have my proper medications, but I was supposed to be seeing a psych nurse to take my proper medications. And I feel like if he was to give me a bond reduction, and I was to get those recommendations, and I was to make bond, I would follow the rules because I take my medications now, which are for my anxiety, depression, and things of those nature. So I feel like a bond reduction is necessary, but no.
So you have your medications now?
No, but I should have them by the 21st.
So what, I mean, anxiety and depression don't make you say things like,
Gonna sit here in front for you. I never said those things, but
you didn't say those things?
no.
You didn't ask her how could she have a boyfriend with how ugly she was?
Never said.
You didn't ask how many boyfriends she ever had? You didn't say any of that. They're just making that up on you, just lying.
I have to.
Have to be lying. You didn't threaten just a couple weeks ago an officer that you were going to throw hot water if she didn't call somebody?
Yes, ma'am.
You did threaten to do that? Okay. Did you say at one point when y'all were getting in trouble that what it had to do with somebody giving a Bible back to another person, and you inserted yourself in something that wasn't about you, and you said, that's what's wrong with y'all officers. Y'all think we on y'all time, and I'm not. So you don't think you're on their time when you're in jail?
I never said that.
What we just witnessed was a masterclass in how not to behave when seeking judicial mercy. You hit on the most crucial point. In the eyes of the court, your behavior in jail matters just as much as the case itself. When a defendant is asking for a bond reduction, the judge's primary concerns are always public safety and flight risk. By racking up a long list of violations, fights, threats to officers with hot water, and disrespectful behavior toward female staff, Jones provided the prosecution with a clear and compelling argument against his release. He essentially showed the court that he can't follow even the most basic rules, so why would a judge trust him to follow the conditions of a bond? The prosecution strategy was flawless. They used Jones's own actions to paint a vivid and undeniable picture of a person who is not only dangerous but also uncontrollable. This evidence directly undermined any argument his defense attorney could make. You also bring up a critical point about the mental health defense. The judge's response was sharp and direct. She made it clear that while mental health issues like anxiety and depression are serious, they do not provide a free pass for threatening officers or engaging in disrespectful conduct. This suggests she sees the mental health claim not as a genuine struggle, but as a potential attempt to manipulate the system and excuse his behavior. The court's job is to discern between a legitimate medical issue and a strategic play, and in this case, the judge's skepticism was palpable.
They made that up too?
What I said was, respect is given both ways. That was my exact words.
Respect is given both ways. And so you think you deserve respect with how you're acting. I got pages of incident reports, and it's pages only starting in June. We're talking about pages over just the last 2 months. Fighting. You've been in at least 2 or 3 fights, right?
Yes, ma'am.
Yeah. Mr. Coleman?
Your Honor, I just a couple questions. Mr. Jones, what did you do with the weapon after Lenny Nixon was shot?
I gave it back to Green.
And when did you and Green decide to rob Lenny Nixon?
Objection, Your Honor. These questions obviously go to the guilt innocence aspect of
I
this.
think you opened that door when you asked him about the shooting and who the shooter was. And the co-defendant.
When did the two of you decide to rob Lenny Nixon?
We never decided to rob him.
So if Green said you decided to rob him before he was shot, he would be lying?
I mean,
Yes or no? Yes or no, Mr.
yes.
Okay.
They'd be lying.
You knew the police were looking for you after Mr. Nixon had been shot, but nevertheless, you didn't turn yourself in, correct?
I didn't know. So
Okay.
after the fact, the next day.
When Lenny Nixon was murdered as part of this robbery scheme with you and Green, you were already under or on bail for UUMV, 2 cases of UUMV, and also a burglary of a habitation, correct?
No, sir, never bailed out.
You were charged with those offenses, correct?
Yes, sir.
You also-
Accusations.
All right. You were also previously arrested for assault on a public servant, correct?
Yes, sir.
Criminal trespass,
Yes, sir.
another UUMV,
Yes, sir.
evading arrest, another evading arrest with a motor vehicle. That's all included in your criminal history, correct?
Yes, sir.
Who is Venetia Jones to you?
I'm what?
All right, pass witnesses.
Thank you. Go ahead, Mr. Wilkerson.
Yes, Your Honor, we've got to circle back over some of those. Just to be clear, Mr. Trevor, not Trevor, okay. Nixon was the gentleman who was shot, correct?
Yes, sir.
And you were staying at Nixon's house when Trevor Green came there. Is that accurate?
Yes, sir.
And in fact, and Trevor Green initially told officers that you had discharged the weapon that had killed Nixon, correct?
Yes, sir.
However, even he corrected that statement ultimately and admitted that it was he who had the weapon, correct?
Yes, sir.
And on that evening, he took your phone, correct?
Yes, sir.
And he provided you the firearm that had belonged to Nixon, correct?
Yes, sir.
Now, you were asked about an agreement to rob Nixon of a firearm. And whether or not an agreement was ever reached. At what point, or at any point, and if so, how did you learn of Mr. Green's intent of removing or taking a firearm that had been in Nixon's possession?
It was about that morning. Well, I'm gonna say around that night, 1, 2 o'clock.
What do you, and you say around that night, 1, 2 o'clock, what is it exactly that you were told at that time?
Nixon keep pointing the gun in our face. Let's just take it.
And how did you respond?
Leave me out of it. I don't want no parts.
And so, just very briefly, you yourself, Trevor Green and Nixon, had the 3 of you grown up together?
Yes, sir. We all went to the same school at one point in time.
Now, Trevor Green had just been released from prison, is that correct?
Yes, sir.
And is it the case that Trevor Green was actually coming into town to spend time with yourself and with Nixon? And Trevor Green, when he came into town, he was with his girlfriend, is that accurate? Okay.
Okay, we're not gonna try the whole case. I gave you some leeway, I gave him some leeway. I'm not gonna listen. I understand there's obviously some differences in opinion as to what happened and who's culpable. So that's all gonna be for a jury or for you guys to work out.
For just a couple more in a totally different direction, Your Honor?
Totally different direction.
All right. Now, you said you were getting your medications on the 21st. What medications are you speaking of?
I'm supposed to be taking trazodone, hydroxyzine, Brazosine, and they're supposed to be giving me another type of med for me hearing and seeing things.
Did you just witness that masterful cross-examination? The prosecutor didn't just ask questions, they methodically exposed glaring contradictions in John Jones's story, one by one. First, we heard Jones admit to a chilling detail. He gave the weapon back to his co-defendant, Green, immediately after the shooting. That single admission speaks volumes, hinting at a clear consciousness of guilt and a calculated effort to conceal evidence. But the most significant legal development came next. When directly questioned about planning to rob the victim, Jones flatly denied any prior agreement. This stands in stark opposition to what his co-defendant, Green, apparently told authorities. This is where the legal reality of this case becomes incredibly serious. The prosecutor's line of questioning is no accident. They are meticulously building a robbery-murder case, a charge that carries far more severe penalties than a standard murder charge. In the state of Texas, the law is unforgiving on this point. If a death occurs during the commission of another felony, such as robbery, every single person involved in that crime can be charged with capital murder, regardless of who pulled the trigger. That's precisely why the prosecutor kept hammering away at the question of premeditation and planning. They are trying to elevate this from a simple murder to a felony murder, dramatically increasing the stakes for John Jones. And let's talk about that criminal history. Assault on a public servant, multiple vehicle thefts, and evading arrest. This is not Jones's first brush with the law. In fact, it appears to be a deeply ingrained pattern. The prosecution is not just presenting evidence of a single crime, they are systematically demonstrating a pattern of escalating criminal behavior. When a 17-year-old defendant comes to court with this kind of record, judges begin to see them not as a misguided youth, but as a career criminal already in the making. The path to a harsh sentence has never been clearer.
So, while you have been incarcerated at Jefferson County Correctional Facility, the psychiatric or psychological staff provided by contract have made a determination that you actually have audio or visual hallucinations?
Yes, sir.
Okay. Your Honor, as a result of that, we will need to request...
Just file the appropriate motion.
Yes, Your Honor. I'll pass the witness.
I have no further questions.
All right. And you said you had another witness. Can you proffer what that witness would be testifying to for me?
Your Honor, that would just be his mother, Venetia Jones, and to the little bit of support that she would be able and really the inability to raise funds.
Thank you. Okay, thank you. And I'm glad she's here. Thank you. Where is she? Thank you for being here, ma'am. Okay, anything else?
Just a really brief argument.
Go ahead, sir.
Yeah, I filed it. I put that argument. I made clear in the state's reply to the defense counsel's motion to reduce the bond, so I'm not going to belabor it. I just hit the high points, Judge. If the court is so inclined, the state constitution, the Texas Constitution, allows you to hold this defendant without bond because he committed a felony while on bail for a felony, Judge. I've cited the case law. I've attached it to my reply.
I don't see that reply on this case.
It would have been filed on August the 6th of this year.
I see a couple of things. I see an order. Oh, never mind. It's right here.
Yeah.
Sorry.
I cite Article 1, Section 11 of the Texas Constitution that states that if a defendant is on a felony, on bail for a felony and commits a subsequent felony, the court is well within its discretion to hold the defendant without bond if it so chooses to. And I've proffered to the court that I've spoken with the juvenile probation, with the juvenile department division of our office, and they have begun the process to certify this defendant as an adult, and that burglary habitation is on its way, should be making its way to your court soon, Judge. We've got the criminal history that I think speaks for itself. Your Honor, we'd ask that this court deny the defense counsel's motion to reduce the defendant's bond. In fact, if the court is so inclined, we'd ask that you hold him with no bond.
Thank you, Mr. Coleman. Mr. Wilkerson, argument?
Your Honor, I think that if you look at all of the incidents that were mentioned by Mr. Coleman, that are all juvenile incidents that have occurred with Mr. Jones, that it is quite clear in conjunction with some of the things that have also been mentioned, and also it fits into some of the write-ups that have been received as well, that Mr. Jones apparently does suffer some mental illness issues, and perhaps maybe we should hold this in abeyance until we can have that properly addressed in order to give the court some additional comfort that some of these behavioral issues might be more appropriately addressed.
Here's what I'm inclined to do at this time. I'm not going to hold the motion. We can always, if circumstances change, file a motion, and I will allow another hearing if there's a change of circumstances. Today, based on the nature of the offense, based on the amount of and nature of the incident reports from jail, based on the amount of and nature of the allegations of criminal history as a juvenile. Mr. Jones is 17, about to be 18, right?
Yes, ma'am.
So based on that, all of that, I am going to deny the motion to reduce the bond at this time. Obviously, it sounds like the jail is doing what they can to get Mr. Jones help. If you want to file a motion with regard to any other competency of whatever you want to file with regard to that, get that filed, and I'll take a look at it as soon as it comes through. All right, you go back with the bailiff. And listen, Mr. Jones, whatever issues you're having, none of that, in my opinion, coincides with how you're behaving, right? So you need to make an adjustment of what you're doing in jail. And if you don't, then Mr. Wilkerson's not going to have any argument whatsoever for me to reduce your bond later or anything like that. So I probably talked to just about everybody in that dorm, I think, in the last couple weeks about this behavior. Y'all can all continue to act like you're acting, and y'all can all sit there and wait for your cases and then go to prison or whatever happens. Or somebody can step up and say, I'm not going to act like that. I'm going to get up when I'm supposed to. I'm going to follow the rules. I'm not going to fight. I'm not going to call names. I'm not going to, all those things. It's not that hard. Just follow the rules. You may not like them. Follow them. And if you can't, then stay in there and keep doing it. Does that make sense?
Yes, ma'am.
All right, go back with the bailiff.
Malik. And there you have it, folks. We've just witnessed a textbook example of how a defendant's own behavior can completely sink their case before it even has a chance to get started. The judge denied the bond reduction, and frankly, after everything we saw, can you really be surprised? What we just saw was a masterclass in legal consequences. Let's break down the legal reality of what just happened. John Jones was asking the court to reduce an $800,000 murder bond, a massive amount that reflects the severity of his charge. Yet, instead of showing any hint of remorse or a commitment to rehabilitation, his actions demonstrated the exact opposite. The judge made it abundantly clear that those pages of jail incident reports, documenting months of fights, threats, and utter disrespect, completely undermined any argument his defense attorney could make for his release. The mental health angle his defense tried to play was seen for exactly what it was, a strategy. The court saw right through it. While Jones claims he needs medication for hallucinations, the judge was quick to point out that this does not, under any circumstances, excuse threatening officers or engaging in a persistent pattern of aggressive behavior. The prosecution's argument was flawless and devastatingly effective. They successfully argued that Jones committed this felony while already out on bail for other charges, a fact that, under Texas law, gives the court every right to hold him without any bond at all. What makes this case so captivating is how it perfectly illustrates the unforgiving intersection of criminal law, genuine mental health concerns, and the justice system's firm approach to juvenile offenders who are transitioning into adulthood. Jones is just a few months shy of turning 18, and his behavior just ensured he will face this murder charge as a legal adult with zero sympathy from the court. The judge's final words were a stark and simple ultimatum: follow the rules, or stay locked up.